The first bill we have is Delegate Jeff Bourne from the city of Richmond, I believe. It's House Bill 5013. This bill has gotten a lot of interest, Jeff, and we look forward to hearing from you. So I'd like to call to the podium Delegate Jeff Bourne.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, House Bill 5013 deals with qualified immunity. And while lots of folks who have testified and spoken opposition to this bill have tried to complicate the matter, it really boils down to a couple of things. First,
can you speak up as much as possible?
I'm sorry. Can you hear me? Is that better?
Yeah, just as loud as you can. That'd be fine.
All right. So this bill really boils down to helping Virginians hold the police and the people that are sworn to serve and protect them accountable. This bill creates a cause of action for a deprivation of state constitutional rights. It allows Virginians to avail themselves of our state courts, much like they can do in federal court. Second, it allows a separate cause of action against the employer or contracting agency for the similar types of actions that have resulted in harm to people. What this bill doesn't do is all of the things that some would say. And to those who would say that it is going to hurt retention and recruitment, I would submit, as my chief co-patron has done on many, many occasions, that if officers are worried about qualified immunity, potentially bringing a lawsuit against them, they might not be the type of people that we want serving our communities and patrolling our streets. Mr. Chairman, members of the committee, we have had and continue to have a unique opportunity to really move the ball forward on justice reform in Virginia. I would submit that this is one of the most consequential bills that we will deal with. And while it will not be the panacea for Black and brown communities across Virginia, this will make their lives a little bit better. This will allow people who have had their constitutional rights violated by a member of law enforcement, allow them to have a full day in court and not have their cases dismissed on a judicially created defense, which has grown and expanded in scope since its inception. And while I mentioned the inception, let's not forget that qualified immunity has its inception back with the Ku Klux Klan. So, Mr. Chairman, members of the committee, I know all of the esteemed members of this committee are relatively well versed on this issue. So I'll stop there. I probably talked too long, and I'd be happy to answer any questions that the committee might have.
First of all, I neglected to ask that the clerk call the rolls and make sure we have a full quorum.
Senator Saslow. Here. Senator Norman. Senator Lucas. Here. Senator Obenshain. Senator McDougal. Senator Stewart. Here. Senator Stanley. Here. Senator Chafin. Here. Senator Deeds. Here. Senator Peterson. Here. Senator Serval. Here. Senator McClellan. Senator Boysko. Here. Senator Morrissey. Senator Edwards. Mr. Chair, you have a quorum.
Yeah, thank you. Delegate Bourne, I'm going to open it up for questions here in a minute. I do want to ask a couple of questions of my own. I understand this bill is derived from 842 United States Code, Section 1963, passed in 1870 as a Reconstruction bill. Is that about right?
That sounds about right if my memory serves me correctly. But Mr. Chairman, as I get a little longer in the tooth, my memory is not as good as it once was.
Okay. It does, however, provide that the employer specifically could be held liable. Is that right?
Yes, sir. It doesn't attach automatic vicarious liability. However, it does allow for a separate cause of action. And really, this bill that is before you now is much narrower than the original introduced version. And that section that you're referring to and asking about was really born out of the idea that oftentimes we'll be at public events, restaurants, bars, and we will see a sheriff's deputy or an off-duty police officer helping with security. However, the issue comes when they have their uniform on. They give the impression outwardly by the clothes that they wear, that they are in fact on duty, members of a law enforcement agency, and so people are right to expect and believe that they are on duty. And so we were trying to protect against those situations where they might not be working for the actual law enforcement agency, but they have in fact worn the uniform that the agency provided and are giving the impression to patrons of an event or somewhere that they are members of that law enforcement agency. It's been narrowed quite significantly to allow for a separate cause of action, but not automatically attach the liability.
Now, is it true that this is the duty of the employer, the liability of the employer is not in federal law? Is that right?
I'm not sure whether that's in federal law or not, Mr. Chairman. What I would submit is that this bill does in fact allow for that as it's in the text of the bill.
Now, is it true that this would, I think there's been some misunderstanding about this bill, that in almost every case that I'm aware of, correct me if I'm wrong, that anyone that's being sued in this, it has insurance. That is, there's a liability insurance covering that person. Is that right?
Yes, that's my understanding, Mr. Chairman.
And right now, again, this is similar to, almost identical to federal law, except for the fact that you specifically said qualified immunity is not a defense to liability imposed in this section. Is that right?
Correct.
Now, the qualified immunity in this section is also in federal law, but not in the code itself. It's judicially created. Is that right?
That is right, Mr. Chairman.
And it's my understanding that qualified immunity that is judicially created in federal law, and it would be in this state code, would, or rather the qualified immunity that's in federal law that you would delete from this particular bill provides basically that the officer would be liable only in the case of violation of clearly established law. Is that right?
Yes, sir. I mean, but and again, I think the point is that qualified immunity or immunity defenses would not be allowed in those instances where we've seen, at least in the federal cases, where it is a extremely high hurdle to overcome to get past the immunity challenge.
Now, as I understand it, I've studied this somewhat, and I'm familiar with this area of the law, and I did some research recently. The area of the question of clearly established law is not that clear, in that it varies from United States courts of appeals to United States courts of appeals. That is, it's not uniform throughout the country. And is that your understanding, or what?
I'm sorry, could you repeat that question again, Mr. Chairman?
Yeah, the question is, what is clearly established law? In some cases, from my research, some judges say it's got to be a case specific to the facts of that case before it can be clearly established. Other judges, it's a looser standard of what is clearly established. So it's not, at least nationwide, under federal law, what is clearly established is not that clear.
I think from generally speaking, that is correct. And I think the former description that you gave about having to be very case specific and fact specific, that each and every element, each and every fact has to be exactly the same in a case that has survived a qualified immunity defense, which is a big part of why it's so difficult to do that, overcome that challenge.
All right, thank you. That's the only questions I have right now.
I have a couple questions.
Are there any other questions from members of the committee?
Mr. Chair.
Mr. Chairman.
Senator
Peterson.
Senator Stewart.
Thank you, Mr. Chairman. Delegate Bourne, I'm not an expert on qualified immunity, although we've had a pretty robust discussion about it today with regard to another bill, and I've learned a lot. But as I read your bill, I just want to make sure I understand it. This bill would actually apply if an officer makes a mistake in judgment. Is that correct?
I'm, I think all these, I think if the officer violates the constitutional rights that are established and clear, then this would allow a lawsuit to survive and not be subject to qualified immunity as a defense.
Mr. Chairman.
Yeah, Senator Stewart.
So, Delegate Bourne, given that officers have to make split-second judgments all the time in very difficult positions where their lives are on the line, they could be held personally liable and sued for everything they and their family have, basically become impoverished from a mistaken judgment, and it doesn't even require an intentional or malicious act on their part. Is that correct?
Mr. Chairman, I would say at least three things. One, I would recall your question about these officers being covered by insurance, one. Two, I would suggest to the senator that most of these cases involving constitutional rights that are being, where justice has been denied, do not involve exigent or split-second decisions. I point to the example in Kenosha, Wisconsin. There was nothing exigent about that young man walking to his car away from several officers and being shot 7 times in the back. And so I would say that this, again, finally, just does not put the thumb on the scale of justice. All this does is say that you are not going to absolve yourself of accountability, you the officer, you the employing agency or employer, by using a judicially created defense with its roots in the Ku Klux Klan era.
Mr. Chairman.
Senator Stewart.
Thank you, Mr. Chairman. Delegate Bourne, I get that. I don't disagree with you when you're talking about shooting an individual in the back, but that's not what we're talking about in your bill. What your bill says is any law enforcement officer who under color of law subjects or causes someone to be subjected, including failing to intervene any other person, to the deprivation of any rights, privileges, or immunities granted to such person under the Constitution and the laws of the United States and Commonwealth, shall be liable to the injured party for compensatory damages, punitive damages, and equitable relief. I just want to make sure I understand your bill, because I'm not talking about anybody who commits an intentional act and does it unlawfully, as we have seen highlighted on the news, should be subjected to all of the things that we've talked about. But this allows an individual who simply makes a mistake in a split decision to be sued and to lose everything they have, and insurance only covers a certain portion. This allows them to be sued for everything they have above the insurance limits. Isn't that correct?
I would submit to Mr. Chairman, I would answer the senator by saying, again, he noted the insurance too. Again, this does not automatically attach liability. This allows the case to be heard on the merits. The judge or the jury is going to decide what the liability is, if any, and then what the level of damages are. It is going to play out no differently than another civil trial where damages are at stake. There's a liability portion of the trial, and then there's a damages section of the trial, unless, of course, obviously the plaintiff concedes to liability and the trial is really just about damages.
Mr. Chairman, one final question. One final question, Mr. Chairman. Thank you. Delegate Bourne, given that the parameters of your bill, and I think we all understand it now, I have one simple question. Who in their right mind would serve as a police officer if they had to be subjected to the kind of liability for errors in judgment and not intentional acts? And how will we ever get people to serve in the police force in the Commonwealth of Virginia?
Mr. Chairman, I would respond to the senator by saying, one, that Mr. there's been a lot of discussion about this bill. And I've heard from the opposition that we don't need this because you can already sue a police officer. Well, that would be part of my response to the senator. Two, if in fact the actions of the officer were lawful, then there's no constitutional violation. And then, so I think we are really trying to give folks access to justice. That's really what it boils down to. I don't suspect that my testimony, my answers to these questions are going to change anybody's position on this bill. But nonetheless, each year we all come here to do what we think is right and represent the people that elected us. And this is one of those bills that despite some strong opposition and some shenanigans that went on, I'm here. And depending on the outcome, hopefully, access to justice will no longer be further denied in this vein.
Mr. Chairman?
Mr.
Chairman?
Senator who? Deeds? No. Senator Morrissey.
Thank you, Mr. Chairman. Delegate Bourne, I first want to thank you for the work that you put in this bill. I know you engaged a lot of stakeholders on this. With that said, my question, though, is going to go to counsel. Is Mr. Quagliato, Charles, are you there? Are you available?
Mr. Chairman, I'm here.
Okay. Let's cut to the chase, and here's where there's disagreement. Everybody in this room right now agrees that if there is a egregious case of excessive force, police brutality, or violation of the Fourth, that police officer should be accountable. We all agree there. The problem, and I'm partly responsible because I had a similar bill, the problem is as follows. The language in paragraph A says the following, and I'm going to cut out the commas and the attendant clauses. It says this: a law enforcement officer who subjects any person to the deprivation of his rights under the Constitution of Virginia, the United States, or the laws of Virginia, United States, is liable. Here's the problem. Charles, why can't we create legislation that specifically spells out a case of police brutality, excessive force, or an egregious case of a violation of the Fourth, instead of this broad verbiage that has allowed so many senators and delegates to say, but what about the split decision matter? Because we all agree that if an officer makes that split-second decision to protect himself or somebody else, we don't want that included in this bill. We want a clear case of brutality and excessive force. Charles, why can't we say that, and why can't we put that language in this bill?
Mr. Chairman, to answer Senator Morris's question, the General Assembly can do that, although I am uncertain that would meet the needs of what the patron intended in terms of trying, and what I mean is everyone speaks of trying to abrogate qualified immunity, and the language in subsection A essentially tracks the verbiage in the 1983 section, 4280 USC 1983, which is essentially the civil rights action claims provided by federal law. The idea, I believe, behind that construction of subsection A was to use that language to provide essentially the case law that supports all of those 1983 claims and to kind of bring those into Virginia. To draft the statute to address what Senator Morrissey has said is essentially, the police brutality situation could be done. but sometimes in drafting legislation, there are concerns about over-inclusion, under-inclusion, being too prescriptive or being not prescriptive enough. So I think the idea was to truly get around the difficulties of, defeating a qualified immunity defense. I think the idea was to essentially use the 1983 language and not allow a qualified immunity defense to be applied.
Mr. Chair.
Senator Morrissey.
Thank you. One final question. And again, Charles, I want to take blame because I think I may have supplied legislation from other states, but I think this bill, which was very similar to my bill, would have had stronger legs if it simply said that the federal defense of qualified immunity is not available to a police officer who engages in an act of police brutality, excessive force, or an egregious violation of the Fourth. That says it.
That's what qualified immunity is.
Mr. Chair.
But so, again,
Senator Morrissey has
is
the
there
floor.
room, Charles, Mr. Quagliato, and to the patron delegate Bourne, to amend that language so that we can be specific, so that the argument that Senator Stewart and others have made about split-second decisions would no longer be valid?
Mr. Chair, to answer Senator Morrissey's question, 1983 claims, there is a provision in the federal code that would allow state claims to be brought as 1983 claims. The problem is that because it's a federal claim and qualified immunity is a federal common law defense, that when looking at the choice of law selections as to what the state courts would apply as what defenses are available, the prevailing thoughts are that the state courts would still look to apply the federal defense of qualified immunity because that is a substantive part of the claim. It's not a procedural part. So that might be the difficulty in just trying to have a statute saying there's no qualified immunity, because without a specific cause of action in Virginia, if you were going under the federal 1983 claim in state court, the state court may still choose to apply the qualified immunity defense because it is a federal substantive defense to those claims.
Mr. Chair.
Senator Morrissey, you finished?
Peterson.
Senator Peterson.
I have a question for the delegate.
Go ahead.
Yes, sir. And my question is, Delegate Bourne, you keep talking about bringing a case to the jury, and I've tried over 100 jury cases in my career. And every case which is tried to a jury, you have to have instructions. And those instructions will set out what the standard is by which the jury can measure the conduct of the defendant. What I don't see in this bill is what the standard is supposed to be. In other words, you talk about the deprivation of civil rights, and as Senator Stewart points out, anytime there's a motion to suppress evidence, if it's successful, automatically it rolls into a deprivation of civil rights. Every time you stop somebody illegally, it's a deprivation of civil rights. Anytime you deny somebody their constitutional right to hunt and fish, it's a deprivation of civil rights. I mean, deprivations of civil rights happen at all times because, like Senator Stewart said, people are making split-second decisions. What is the standard by which the jury would judge the officer's conduct? That's what I don't see in this bill.
Delegate Bourne.
Mr. Chairman, I would say to the senator, I think the standard is whether or not those constitutional rights were deprived and whether or not they were reasonable under the circumstances.
But where does it say reasonable in your bill? Where does it say reasonable?
Well,
It doesn't say that, does it?
no, it does not. I do not believe them.
And I think quite candidly, sir, and I appreciate this bill, and actually, ironically, I was thinking about doing a similar bill on qualified immunity. The fact that there is no standard by which to judge this conduct, it makes it really tough on this issue.
Mr. Chairman, I would say that the standard is the constitutional rights. We know when our constitutional rights have been violated, and that's for the trier of fact. I would say that If you're looking for a reason to oppose this bill, I'm sure there is one out there.
Sir, I'm not looking for a reason. I'm asking you for a reason why we should pass it when, again, it would open up liability for every single officer that is simply doing their ordinary duties.
So, Mr. Chairman, I would say to the senator that what's stopping anybody from suing police officers today in Virginia? I would say nothing. The only thing, the thing that we're changing is that they can no longer hide behind the shield of immunity. That's what this bill boils down to.
Well, sir, I'd simply say, and then I'll be quiet, again, I understand the immunity argument. And in fact, I agree with you that qualified immunity is something that needs to be not just looked at and perhaps revised, but the problem is you have a cause of action with absolutely no standard. I can't think of a single profession in this Commonwealth where if I'm sued as an attorney for malpractice or a physician is sued or somebody is sued and makes it for making a mistake, there's not some standard which says whether or not, you know, they did or did not achieve that standard in their conduct. And here we have no standard. It's just if there's a violation, they're automatically guilty and punitive damages.
Mr. Chair.
Delegate Bourne?
Mr. Chairman.
Mr. Chairman.
Yeah, Senator from Rockingham.
Mr. Chairman, a couple of questions. Delegate Bourne, isn't it true that qualified immunity doesn't even apply unless there is a constitutional deprivation?
Yes, that's true.
And isn't it further true that the reasonableness standard that you and Senator Peterson were talking about is exactly what qualified immunity provides?
Mr. Chairman, I would say to the senator that again, you can never get to whether or not those actions were reasonable or prudent if they're raising the qualified immunity defense and the case is cut off. What I would also say is even in those few instances where a judge has said not allowed the qualified immunity defense, there is an automatic right to appeal to the Fourth Circuit, which is where many of these cases, at least in our area, are reversed. And so, again, I don't want to overcomplicate this because we're really saying that you don't get off with this judicially created defense when you have clearly violated someone's constitutional rights.
Well, let me just follow up, Mr. Chairman. So you say that you never get to that factual question because of qualified immunity. Isn't it true, first of all, that there are two questions? One is the question of law as to whether the right is clearly established. And that, if it's not clearly established, isn't it true that you're right, you would a plaintiff would never be able to get by that? So that does provide a barrier, right?
Yes, sir.
But then second, the question of whether the act was an act that a reasonable police officer could have believed to be consistent with that clearly established constitutional right is a question of fact that has to be determined by the court. So you do get to that question of whether it was reasonable or not if the right is one that is clearly established.
Delegate Bourne.
Mr. Chairman, I would say you don't get to that, and I think that's the whole reason why we're approaching this bill. And so
under what circumstances? I'm sorry.
Senator Bourne, Delegate Bourne, go ahead.
Mr. Chairman, what I would say is that's the defense. It's early on in the process, and I mean, obviously Mr. Quagliato is much more well-versed than I am, and so I would ask that he weigh in to clarify.
Okay. Charles
Mr.
Quagliato.
Chairman, so the qualified immunity, there's a two-step sequence that has to occur. And the first step is whether the facts alleged or shown by the plaintiff make out a violation of a constitutional right. And the second step sequence is, if so, whether the right was clearly established at the time of the alleged misconduct. And in I guess it's in 2009, the U.S. Supreme Court held that either one of these steps would essentially defeat the plaintiff's action. So it's not really two steps anymore, it's two prongs, and either prong will bar the proceeding. And as Senator Obenshain kind of, in his question, he did say, well, if you have a right that is clearly established, don't we get to the factual issue? And it's not quite there yet, because even assuming, and a lot of this has to do with burden shifting, and that's kind of one of the problems with qualified immunity, it reverses a lot of the burden shifting back on the plaintiff. The plaintiff still has to meet that first prong and show that there is a violation of a constitutional right. And that's, so even if you can show that the right is clearly established, they still have to then at least make out a case that, that right that has been violated.
Further question.
Senator Obenshain.
Isn't it true also that most law enforcement agencies in Virginia are insured, and I think in response to Senator Edwards' question of insurance came up, by either the Commonwealth of Virginia's Division of Risk Management or by a VML or VACO policy?
Yeah, I'm not sure which localities or their agencies are covered by which policy, but yes, they're all covered by insurance.
Well, you'd agree that, probably 99% of them are covered by those three carriers.
Mr. Chairman, I'd respond yes.
And further, that the limits of those coverages are, I think for all of those coverages, are $1 million per incident for the officers involved, correct?
Delegate Bourne.
I'm not sure of the limits or coverages.
And that there is no limit on the liability either under your bill or federally.
Mr. Chairman, I would respond, that's right. There is no limit on liability in this bill.
And you mentioned the Kenosha, Wisconsin shooting where the victim was shot 7 times in the back. You would agree that it's highly improbable that qualified immunity would be a viable defense in that case, wouldn't you?
Well, Mr. Chairman, I would say to the senator that in a perfect world, I'd like to believe that. However, in reading some cases, most notably from Judge Reeves, there were several examples cited which are equally egregious, and I'll just point to one where an officer came in, was attempting to shoot a dog and shot and killed a little girl, and he was absolved of liability and immunity because of qualified immunity. And so if we have our rose-tinted glasses on, sure, we would all agree that should not survive qualified immunity, but I live in the real world, and I'm not naive enough to believe that's a slam dunk proposition.
Well, and Mr. Chairman, following up on that, in Kenosha, Wisconsin, the police officer intended to shoot the victim, right?
Yep.
I assume that's what he was intended to shoot.
In
the case you cited, the officer intended to shoot the dog and not the little girl, though, right?
I would assume so, yes.
Okay.
However,
so those are very different cases.
I would submit to the senator that the question should be, was it reasonable or prudent for the officer to shoot the dog with the little girl in harm's way? I think anybody that's ever handled a gun, taken any firearm safety classes, knows that knowing where your target is and what's beyond your target is a critical skill to have and develop when you have a firearm.
Thank you.
Any other questions?
Mr. Chair.
Senator Dees.
Delegate Bourne, I'm looking at subparagraph A. I'm thinking, this past session, we passed legislation that allows the removal of firearms in extremely risky situations. There's nothing in paragraph A that would prevent someone whose firearms were removed under an extreme risk order, they're removed by a law enforcement officer, from suing that law enforcement officer alleging that his Second Amendment rights have been violated, is there?
Mr. Chairman, I would say to the senator that I don't think there's anything that would prevent that. However, there's no liability that attaches for enforcing constitutional laws. And unless that law was found to be unconstitutional, I think the officer would prevail in that case.
Senator Deeds? Are there any other questions?
Mr. President. Mr. Chairman. Mr. Chairman, I'm sorry. Surville.
Senator Searle.
Thank you. And Mr. Chairman, I have a question for the patron. And like Senators Peterson, Morrissey, and I believe others on this side, I would like to see us do something about qualified immunity. I think it's a huge problem. But I'm likewise worried about the unintended consequences. Let me throw this scenario at you and let me know what your view is on it. The way I read the bill, it says that if any law enforcement officer under color of law subjects somebody to the deprivation of any right or privilege granted under the Constitution and the laws of the United States and the Commonwealth. So it also applies to deprivation of privileges under the laws. Can you explain to me how, for example, a police officer who's driving a car and say is speeding, breaking the law about speeding, and perhaps hits somebody in a car or a pedestrian and injures them, and say that person's contributory negligent. Maybe the person just jumps in front of the car, but the officer was speeding. I don't know. I mean, how is that not picked up by this where it says they shall be liable? I mean, how does this statute not rewrite the law of that situation, which I don't think it's really aimed at, but how does this language, can you explain to me why that wouldn't be covered?
Sure, Mr. Chairman, what I would say to the senator is, obviously in that case, contributory negligence is not addressed in this bill. And so I believe that officer would have the defense of being contributory negligent and therefore be absolved of any liability.
Mr. Chairman, further question?
Senator Searle.
A delegate, I mean, I would say the delegate, maybe he could, this says they shall be liable, so it doesn't say they get the benefit of contributory negligence, and it also makes available attorney's fees and costs, which right now you can't get for a car accident. And so I'm not clear how the delegate thinks you can get contributory negligence in this when it says you shall be liable and it doesn't say anything about affirmative defenses anywhere in the bill. So, I mean, can you point to me how contrib would come into play if it's not mentioned here at all?
Delegate Bourne.
Sure, I think, Mr. Chairman, I would say to the senator that the only two defenses that we are dealing with in this bill are qualified immunity and sovereign immunity, or other statutory immunities or limitations. And so, while we're continuing to talk about this, again, I would submit that the accident scenario hypo that you presented is one of those that I think is doesn't fit within this, and it's not aimed at those, and we can certainly stretch our imaginations to find a scenario for any bill that we consider that it wouldn't address. But again, I think all this boils down to is, are we going to allow Virginians to avail themselves of our state court systems when their constitutional rights have been violated? And, I've heard a lot of people say we've got to do something, we need to do something. Well, there are people sitting in the committee room right now who have the opportunity to do something and do the right thing. And so I'll stop there, Mr. Chairman.
Mr. Chairman.
Yes, Senator Searle.
Mr. Chairman, one last question. So I just want to make sure I think I heard the delegate correctly with regard to the question from Senator Deeds. And one of my concerns about this is, given that the right to bear arms is in the Second Amendment and in the Constitution of Virginia, and as the U.S. Supreme Court has presently interpreted it, has really sort of really weaponized the Second Amendment in a new way that wasn't the law for 200 years. Doesn't this bill create a new legal remedy for someone to challenge every single one of the firearm violence laws that we just passed last session, whether it's red flag, whether it's background check, or whether all the ordinances that are currently going on the books? For example, I saw the City Council of Richmond just passed a law prohibiting firearms at protests. I mean, doesn't this bill give anybody who is unhappy about being charged with a violation of those statutes a civil cause of action where the police can no longer claim qualified immunity?
Delegate Bourne.
I think, Mr. Chairman, I would say to the senator that, as Mr. Quagliato explained, the first prong is, or one of the prongs is it a clearly established constitutional right? And I think despite the weaponization, as the senator has described, of the Second Amendment by the court, the Second Amendment, obviously, as we've seen, is not absolute, and that states are allowed, as we have, to enact limitations on that. And unless and until any of those gun violence reduction bills that we passed, that I was happy to vote for, are found unconstitutional, the law enforcement officers would be in their right to enforce those laws.
Mr. Chairman.
Senator Serval.
I don't have any other questions for the delegate right now.
Mr. Chairman, Senator Stanley.
Senator Norman? No.
Stanley.
I can't hear.
Stanley.
Senator Stanley, hot dog.
Right behind you. Thank you, Mr. Chairman. I'd ask my friend, the patron of this bill, a couple questions if I can. Senator Obenshain had discussed with you that there are no limits, and I don't see any limits of what liability would be. Are you aware, Delegate Bourne, of any policy where qualified immunity, perhaps in other states, has been limited in this fashion as your bill attempts to do here in the Commonwealth of Virginia? Do you know of an insurance product that would cover an individual police officer or a county, city, or town that employs police officers for this kind of thing if liability attaches?
Mr. Chairman, I would say to the senator that I've not scoured all the insurance companies that provide this type of insurance, so I would even be hesitant to guess. A lot of this language and this approach was modeled after what they did in Colorado, to answer the first question.
Mr. Chairman.
Yes, Senator Stanley.
Thank you, Mr. Chairman. Jeff, when we contemplate this as when you talk about damages, you talk about compensatory, which are limitless, punitive, which has a statutory limit, and then equitable relief. Could you tell me what you envision in this bill? What equitable relief would be available to a plaintiff if they sued under this bill?
Mr. Chairman, I would say to the senator that I would not presuppose what an equitable relief would be, because I suspect that the trier of fact, should the case get to that point, would take all the totality of facts, circumstances, evidence into consideration and fashion equitable relief in as much as those facts and circumstances and evidence led them to.
Mr. Chairman.
Senator Stanley.
Yeah, and thank you. And Delegate Bourne, one of the big concerns, and especially in my rural areas where we have less of a tax base than some other more economically vital, with vitality areas like Northern Virginia and Richmond and the like, a lot of the concerns that I'm hearing from my local government officials is who pays. They pay into a risk management policy. There's those kind of issues. But would the county also then be liable through this vicarious liability section 8.0142.7 under line 28? Would they not be, this clearly attempts to establish vicarious liability for negligent retention, hiring, et cetera, would the county then be also liable for damages under this theory, under this new theory of and cause of action here in line 28 through 36, 34?
I think Mr. Chairman, as I read that bill, that would be a separate cause of action that would be brought, and they could be liable for that. Yes.
Okay, and therefore, Mr. Chairman.
Senator Stanley.
And therefore, if they're liable, then of course any damages that would be awarded to the plaintiff in a cause of action such as this against the public entity under 8.01 42.7 as you propose, unless they had a insurance policy as I had asked you earlier, then the taxpayer would pay all the damages or any income and revenue generated by that locality, however it derived, it would be the way that they'd pay for these damages to a successful plaintiff. Is that correct?
Mr. Chairman, I would say that as a general matter, yes, but I would also submit that the taxpayers, at least, well, I wouldn't say all of them, because we know that these situations happen more predominantly in one community than the other. We're paying a social cost, and that social cost is black people dying at the hands of bad actors, bad cops. And so their families have no great ability to get recourse and redress. And so this is a piece of the puzzle to what we are here to do during this special session. But I would submit that there is a social cost that needs to be factored in our decision making.
Mr. Chairman.
Senator, who's that?
Morrissey.
Morrissey.
I'm going to propose an amendment to it, and if there is a second to it, I'd like to speak to it. That amendment would be as follows. On line 13, where it says under color of law, comma, after color of law, comma, delete the rest of line 13, all of 14, all of 15, and the first three words of line 16 and the Commonwealth, and insert engage in an act of either police brutality or excessive force. So it would now read, any law enforcement officer, as defined in section 9.1-101, who under the color of law engages in an act of either police brutality or excessive force shall be liable to the injured party. That's my motion, Mr. Chair.
Is there a second? Is there a second?
Mr. Chairman.
Second.
Okay, is there a second? I didn't hear.
Second.
All right, speaking to the motion.
Go ahead.
Thank you, Mr. Chair. And Delegate Bourne, I also want you to weigh in because this is your bill. First of all, the language that I deleted is very broad, and it would include the following, and Senator Stewart brought this up. Every time a criminal defense attorney was successful on a motion to suppress, or say even a Frank's motion, that attorney is arguing to the judge that his client's Fourth Amendment rights were violated. If he prevails, which happens frequently, the next step would be go to next door to the civil court. That's not what we're after here. We are after a mechanism that will allow a plaintiff to sue the police for what Delegate Bourne just described, an act of brutality or excessive force that results in serious injury or death. And the second point that I want to say is this. I am very mindful of what our staff attorney, Mr. Quagliato, did. He had a very difficult burden. Qualified immunity is a federal common law defense. Therefore, when this matter is raised in a state court or sister court, then you have a choice of law. What do you apply, federal or state? And because it is a federal common law defense, the choice of law reverts back to federal law. So Mr. Quagliato, I think, tried to navigate that as best he could. But at the same time, I think it's created a problem. So for that reason, I propose that motion. It narrows it down Mr. Delegate Bourne, to what we all want to prescribe. And I think it's only fair and courteous to ask you to weigh in on that motion, which has been seconded.
Mr. Chairman.
Who's this? Senator Obenchain.
And Mr. Chairman, I respect what Senator Morrissey is attempting to do. However, it highlights the difficulty of the task at hand, certainly also the difficulty in doing this on the fly. The problem with this amendment is the same problem as with the bill itself. Police brutality and excessive force are to be judged by what standard? Are they to be judged by a constitutional standard or some other standard? I suspect that Senator Morrissey intends for them to be judged by a constitutional standard. Take, for example, situation of someone reasonably but mistakenly shot by a police officer. Somebody who a police officer truly, and any police officer would have believed posed a threat to his or her life, and the police officer shot that person. That is excessive force because it was a mistake. They did not, but were reasonably believed to pose a threat to the life or health of that police officer. So this would impose liability on police officers for making reasonable mistakes, just as the underlying bill would. Moreover, it provides no standard by which police brutality or excessive force are to be judged. And then if you were to apply the constitutional standard, you go right back to the statute or the bill as drafted for Delegate Bourne. I just regret that I understand what Senator Morrissey is doing or trying to do, and I think that even listening to Delegate Bourne, I commend him for what he's trying to do. I mean, we all want to punish unreasonable uses of force by police officers, and that is the difficult task that qualified immunity addresses. It does draw a line between the reasonable, and the unreasonable. It would be written in code if it could be. But like many things that we try and tackle in here, it's like playing whack-a-mole. If we draft it too broadly, we're going to catch situations we don't intend to catch. Delegate Bourne said in response to a question that the vast majority of cases that would be covered by this are going to be the cases that are the egregious cases. Yeah, and I want them to be prosecuted. I want them to be liable. But the ones that I worry about are the minority of cases, the cases where the police officer did not do anything wrong.
Mr. Chairman.
And that's what we're catching with this amendment and with the underlying bill. And it's not because of any malice by Delegate Bourne or Senator Morrissey at all. I commend them for what they're trying to do. But it cannot be done in this fashion.
Mr. Chairman, would the
Morrissey,
Senator from
Senator Morrissey?
Senator Obenchain is correct, full stop. The amendment should have been, and he's right, because it doesn't set forth a standard. The amendment should say engage in an intentional act of either police brutality or excessive force. So the full amendment now would read, after under color of law, comma, engages in an intentional act of either police brutality or excessive force.
Delegate Morrissey, it's Senator Morrissey, can you explain to me or anybody the definition of police brutality or excessive force? These are pretty broad general terms. What are the elements?
Well, you know, I took a course on legislative interpretation at Georgetown about 50 years ago. And the expression that comes to mind is the normal and usual meaning of the word. So I can't, if I started to define right now police brutality or excessive force with some type of language, I would do in justice, Mr. Chair.
Let me make a comment about this. The problem with that language is loose. There are cases defining what a deprivation of a constitutional right is. But I don't know of any definition of police brutality or excessive force. It's more of a colloquialism. That's the problem with it. That's my comments. Would anybody like to, Charles or Delegate Bourne, like to comment on that?
Sure, Mr. Chairman. What I would say is I certainly respect the effort that Senator Morrissey is making with the amendment. However, it causes me a little bit of concern because, as we know, sometimes negligence is so bad that it is grossly negligent. I think, as the chairman has stated, we have a plethora of case law that defines these constitutional deprivations. This language was derived largely by Section 1983, which has been around for a long time. I think, obviously, as Senator Morrissey can attest to better than I can, certainly better than I can from his time as a prosecutor, the mens rea, the intent element is oftentimes the most difficult to prove. And so I would not like the amendment, but I understand that I am in the Senate before the Senate Judiciary Committee, and I understand the legislative process to know that it will be the will of the committee about what happens.
Mr. Chairman. Senator Stewart.
Senator Stewart.
Mr. Chairman, I've got a substitute motion if it's appropriate. Mr. Chairman, I commend Delegate Bourne for what he's trying to do, and I agree with him on a great deal of these cases, as others have said in this room today, but this is a really difficult nut to crack, and I think just by Senator Morrissey's attempted amendment, we begin to see how difficult it gets and the unintended consequences of trying to work through this bill on the fly and the unintended consequences of the bill as drafted. And so I think we need to think about this a little more, maybe work on it when there's more time. And I would just move that we pass the bill by indefinitely.
It's been moved to pass the bill by indefinitely. Is there a second?
Mr. Chair,
Senator Deeds.
If we're going to do that, I would hope that we would take the same step we took with Senator Morrissey's bill and pass the bill by definitely with a letter from the chair to the Boyd Craves Commission to study this complex issue and hopefully come up with a solution. Okay, I think the questions and the motion and the discussion around Senator Morrissey's issue, our amendment points out to some of the very complicated issues that surround this bill. None of us want police brutality, and we want to be able to address this, but this bill is so much broader than police brutality. This issue needs to be addressed. You know, we took the same, we had this motion with the letter that got out with respect to Senator Morrissey's bill that passed this committee 14-0 3 weeks ago.
This bill is identical to Senator Morrissey's bill. Is that right?
It's similar, I think.
Mr. Chairman, I can amend my motion if that's appropriate. I would amend my motion as described by Senator Deeds.
It's been moved and seconded.
Mr. Chairman?
It's a substitute motion.
Mr. Chairman? This is me, Delegate Bourne.
Yeah, Delegate Bourne. Yeah, please.
I know in the on the other side of the chamber, we oftentimes give the patron the last word.
Sure.
Is that the practice in the Senate?
Sure, please do.
Okay, thank you, Mr. Chairman. Mr. Chairman, members of the committee, I certainly appreciate the time and the robust discussion about this bill. This has been one that has been born out of love, heartbreak, and tragedy. Moreover, Mr. Chairman, members of the committee, I do not disagree that this is a difficult issue to tackle, but it's not complicated. It makes people uncomfortable. And if we're ever going to change, we've got to get to an uncomfortable place. Mr. Chairman, it was remarked that this is a tough nut to crack. But in closing, let me just suggest to each and every member on this committee a tougher nut to crack. A tougher nut to crack is trying to explain to your 8-year-old son why he has to carry himself differently and why daddy might get nervous if a police officer pulls him over. A tougher nut to crack is trying to explain to your 12-year-old daughter walking around the Marcus David Peters Circle, formerly the Lee Monument, why all those people that look like her died at the hands of police officers. And Mr. Chairman, members of the committee, if this bill can help one family, one victim, I would urge you to oppose the motion to PBI, move to pass it out of the committee onto the Senate floor, and let's get it to the governor's desk.
Mr. Chairman.
Who's this?
McClellan.
Delegate, Senator who?
McClellan.
I didn't hear.
McClellan.
Oh, Senator McClellan, sorry.
Thank you, Mr. Chair. Speaking to the motion. Look, I'll be the first to admit this is not an area of the law that I'm an expert on. But here's what I do know. And there was a federal court, a 72-page federal court ruling by a judge in Mississippi, Carlton Reeves, that walked through the problems of qualified immunity, that talked about how qualified immunity, whether intentionally or not, has become a shield where someone can shoot first and ask questions later, and there are no consequences. And two Supreme Court justices who don't agree on a lot of things, Sonia Sotomayor and Clarence Thomas, have pretty much said the same thing. And for too long, in Black and brown communities, and particularly low-income Black and brown communities, the tendency of police officers to shoot first and ask questions later, or pull a gun and ask questions later, has led to a loss of faith in police to keep those communities safe, where people are afraid to call the police because it could lead to a loved one being killed, even when police are called to help that loved one. And for too long, there's stories after story after story after story where a mindset of, I have to come home at any costs among some police officers has led to death where it didn't need to happen. Even something as simple, and I never told this story until a few weeks ago because I kind of blocked it out. When in the Fan in Richmond, when my father came to my house to water plants, and because my neighbor's mother had never seen him before and called the police, and my father figured out police were there when he felt a gun to his back and was told, put your hands up and turn around. And there was something going on that caused the police officer to think that seeing the back of a 70-something-year-old man in a yard was cause for him to pull a gun out. And my father is my complexion, or was my complexion. And I remember having a conversation with my brother-in-law, who was much darker, who said, if that had been me, I could be dead. And so I want to reiterate something that Delegate Bourne said, that we have had these conversations in the Black community for decades. And qualified immunity has become a shield where we're afraid. Because if something happens, there is no recourse. And we've got to do something about that. And we take the time to deal with things that are complicated all the time. And yes, I voted, as did Senator Morrissey, to table his bill because I had hoped we would have more time to figure this out by the time the House bill came. And I know how this vote's going to go. But we got to figure this out. We got to figure this out because if we don't, there are young people, yes, they're the ones marching in the street, who are angry, who are frightened, who have totally lost faith in our ability to solve this problem. They've lost hope. And if they lose hope, we're all lost. So if we're not going to fix this today, I certainly hope we don't just leave it to the Boyd Graves Conference to do it, that we figure out how can we create a cause of action in Virginia. If this isn't the way to do it, if just saying no quality, if this isn't the bill to do it, just create a cause of action, which whatever standard you want, that says if you shoot first and ask questions later, there's going to be accountability, because right now there's none.
Mr. President.
And for that reason, I'm voting no on the motion.
Mr. Chairman.
Mr. President.
Mr. Chairman.
I can't hear. Who is it? Senator Stanley? Senator Norman.
Mr. Chairman, speaking in favor of the motion, I do have some experience of practicing law in this arena, and I have some experience from an academic standpoint in instructing law students in this area. And I would ask everyone to think in this perspective. First of all, I would say to the delegate, I am not the least bit uncomfortable having this conversation. Not the least bit uncomfortable, because I think it is a meaningful conversation that deserves our deliberate consideration. But I would say, look at the perspective of what we have been hearing on justice and social reform through this special session. How many times earlier today on Senator Locke's bill did I hear how that omnibus bill was historic? There have been significant pieces of legislation that have been moving through both the House and the Senate that are historical in the sense that Virginia is recognizing that substantial changes must be made in this area. We've got the citizen review boards. We've got the crisis intervention teams. There is a plethora of legislation. Doesn't mean that things are perfect, but what it does mean is that we are moving on that issue. And I suggest that not acting on this qualified immunity bill at this time is not just throwing it to the wind. We're going to have an opportunity between now and the next session and during the next session to see how some of these historical reform legislations work. I would further say to you that this morning before I came to the special session, I was reading Lawyers Weekly, which I do religiously. And in the past 10 days in the United States District Court for the Eastern District of Virginia, here in Virginia, the judges made a decision that an officer and an EMT who had acted inappropriately that resulted in injuries to a minority individual were not entitled to the defense of qualified immunity. So it is not that there's a total vacuum that exists in this area. So I would rise in support of passing it by indefinitely.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
Senator Stanley.
Favola, Boysko?
Boysko and Stanley.
Boysko?
Ladies first.
Senator Boysko.
Thank you, Mr. Chairman. I am really torn on this. You know, the personal story of my good friend from Richmond sharing, is painful to hear. And as is the story that Delegate Bourne talked about, having to teach his children that they're going to be treated differently. However, I also had the expectation that the bill that we passed earlier today on police reform is going to be addressing a lot of those wrongdoings. And I don't know if this is a question to council or to someone else in the room, but have we not made adequate progress so that those people are protected better? And if so, I mean, I think it's a horrible situation to have to try to balance these things out, and I understand that's what our charge is, and that's what we ask to be senators for, to make these difficult decisions. I share the sentiment with everybody else in the room that police brutality and the killing of innocent people because somebody's not taking the time to think through what they're supposed to be doing, and then getting away with it is abysmal. I'm really struggling right now about where I'm going to decide. I came into the room thinking that I was for sure, thinking that qualified immunity was too complex for us to do. This is what we've been discussing, that there are so many components to it that we aren't going to give it due diligence. I would like to hear from somebody else, though, before we take a final vote.
Mr. Chair.
Mr. Chairman.
Mr. Chair. Peterson.
Lucas.
Peterson.
Yes, sir, Mr. Chairman. I've listened with great interest to all of the statements that have been made on this qualified immunity bill, and I'm not the least bit torn. We have what I think is a movement behind us in terms of getting this qualified immunity bill passed. I'm not the least bit confident that if we put this bill off to another session, or either send it to board grades, or whatever we decide to do this afternoon, and I pretty much think I know where it's headed. I'm not the least bit convinced that there will be any number of brown and black people who will be killed by police officers by the time we come back to the next session.
Mr. Chair.
There's so much more that I could say about how I feel about this, because it's not just our young children, it's not our children, just our children that we're having to talk to. Some of us stand in fear of the police in our own communities. And it doesn't matter how much you've accomplished in your lifetime. If you look like me, most of us are afraid of the police officers in our communities. It's for that and many other reasons that I intend to vote for this bill. It doesn't matter to me what everybody else thinks about it or how they vote. But my conscience tells me that if we keep kicking this can down the road, that we will continue to see black and brown people dead in the streets at the hand of local police departments. There's a critical mass behind us to get this bill passed. And I personally have the courage to vote in favor of the bill, and for any other motion, I will vote no.
Mr. Chair.
Mr. Chair.
Senator Peterson.
Yeah. Mr. Chair, speak to the motion. Mr. Chair, earlier today we passed Senate Bill 5030. That was our police reform bill. One of the aspects of that bill had to do with not just banning chokeholds, but it also had to do with illegal shootings. It had to do with a standard for illegal shootings. It had to do with a standard for excessive force. We just spent an hour debating that bill, and now it's as if it never happened. Not a single speaker yet has referenced that bill, which we just passed, which had standards which would allow a police officer to be charged and go in front of a jury, and there would actually be a standard of conduct by which his conduct be measured. And not a single person has referenced that. It's as if it happened and it disappeared. Here's the point. Delegate Bourne's bill comes from a good place. It came from the same place as the bill we debated 2 hours ago, but it's very broad. It has no standards. It has no standards whatsoever. It's drawn on Section 1983, which was a civil rights statute passed back in 1870. which happened in the context of Confederate states which were denying the civil rights of their African American citizens. And because of that, the U.S. Congress passed a statute which basically forbade state and local governments from denying people their civil rights. Well, I got news for you. The Commonwealth of Virginia right now, all the statewide officers are Democratic. Most of the large cities are controlled by Democratic mayors. So the bottom line is this is a different situation than the Commonwealth of Virginia in 1870. So you're taking language that was being used to basically break down the structures of, in that time, 1870, the old Confederacy, and you're trying to put it on a situation in 2020 where, again, this is an issue that we've already tackled. Now, I'm not saying our solution is perfect. It may not have been perfect, but we just addressed these issues not but 2 hours ago, and now we're acting like that didn't happen. Now, let me talk a little bit about a group that I have somewhat familiarity with, and you can tell by, listen, I've been very fortunate in my life. I grew up in a Fairfax City, same place I live in now. A lot of the kids I went to high school with, they became cops in the city. I knew them real well. And you know what? By and large, they were good people, okay? I have so many stories I have, and I'm not saying my life is typical or my experience is typical, but I do reference one story which I think is important because we spend a lot of time talking about police officers that are problems. And yes, they should be prosecuted. But I will also tell you about incidences where police officers went above and beyond the call of duty. 5 years ago, I was a soccer coach for my son's team. And there was a little boy who was Hispanic, didn't speak a word of English. And every day he would come to soccer practice, he would be driven by a police officer. He would take him to the practice. And I talked to the officer, I said, is this some type of court-ordered program? He said, no, he lives in my apartment complex. He didn't seem to have any friends. I asked his mom if I could sign him up for the team, and he would take him to practice every day. This was on his time, not his kid. Now, that's not unusual, okay? The bottom line is we shouldn't be telling police officers we're going to pass a statute with no standards that's like a Jackson Pollock painting. Whatever you throw against the canvas you can be liable for. We had a very good bill we passed, Senate Bill 5030, which had standards, and police officers know to fit those standards. Let's let that bill work. Let's let that bill pass. I trust that the House will pass that bill. But in the meantime, let's stop, again, let's have some degree of reason here. I listen to my colleagues. I appreciate their statements, but we have passed landmark legislation. This bill needs to be set aside so we can let other bill work. Thank you.
Mr. Chairman, Senator Stanley.
Senator Stanley.
Mr. Chairman, I want to thank everybody who's talked today, and I especially want to thank Delegate Bourne. He's very passionate about what he believes in. I've seen it in bills that we've worked on in criminal justice reform, criminal discovery reform, school discipline, and so I admire his passion, and especially when he believes in something. So I never question what his motives are whenever he brings a bill. I agree with him, and I think everybody on this side of the aisle would agree, as I do as a 26-year practicing attorney in the Commonwealth of Virginia, that a violation of one person's constitutional rights by a government actor is in fact a violation against us all. It is our duty in passing laws that they be colorblind, because true equality in the Commonwealth of Virginia is within every single person, no matter where they come from, no matter what they look like, is treated equally under the law. That's our goal here as legislators as well. But what I fear is, especially in these kind of pieces of legislation, and especially if we were to pass a bill like this, is that what we would see is a mass exodus of very good police officers who weren't willing to risk their livelihood. They're willing to walk out every day out of that door, kiss their wife and their children goodbye, and risk their life, but not their family's livelihood, not their financial security. And so what I fear is that we will see a mass exodus of those very good cops who then leave the profession because they don't want to take even that risk. And how can you blame them? Quite frankly, who does that leave? Because we don't pay them well enough to begin with. Well, that leaves probably more of what we all have said are the not so good cops. And that would be an unintended effect that I think would be detrimental to our communities, detrimental to societies. The other thing is here, I find it kind of strange and in a way that here we are wanting to strip away immunity protections from certain government officials, certain government employees, but yet we enjoy those immunities. So we're going to take immunity away, this governmental immunity. Then don't limit it to the police. Take it away from all of us as well, if that's what the discussion is going to be. Sorry, Senator Zaslaw, if we're going to do it, then let's let the laws apply to us as well. Because then we owe everybody that, because we stand on equal footing. So what I'm seeing here, unfortunately, is from all of this discussion, again and again and again, and even this bill moving forward, stripping qualified immunity, putting families of police officers at financial risk from lawsuits, frivolous lawsuits or whatever, putting counties at risk of going bankrupt if they were to suffer a judgment that they were then liable for under third-party immunities. But what I've seen, and I don't like it now, I've even seen it in my own county, my home county of Franklin, is an erosion of respect, of authority for the good police officers. We had a police officer who waited in line, just wanted a meal over the Labor Day holiday. 32 minutes, never served. People going around him in the second aisle. Everybody else got through the drive-thru. He was never served. He asked to see a manager. They wouldn't let him do it. And that company, that restaurant said, well, it was because of understaffing issues, not admitting the truth of what it really was. He wasn't being served because he wore a uniform and was in a marked police officer's car. What I hope in all of this, when we discuss police reform, is ultimately that in police reform, we do it for the right reasons, we have the right effect, but we're not doing it as an act of degrading the officers, the men and women who wear that uniform and leave their house every day to keep you and I free, you and I safe, and our property free from others' interference. And I will close by this, Mr. Chairman. I cannot stand when there is a victim of someone, when someone's life has been taken by a police officer wrongly. I join the senator from Rockham in saying I want them prosecuted, and they should be liable when it is a horrendous act such as this. But let us also not forget people like Trooper Michael Walters, killed here in the city of Richmond, the Greyhound bus station, doing his job. No reason, no earthly reason that he should not be on this planet right now. So let us remember all of the victims. Let us do better to make sure that we're not just picking one set, but that everybody, every bill that we work on is to try to protect every victim from wrongful, violent crime. And so I believe that this bill itself will erode that faith in law enforcement even further in the communities, to allow them to treat police officers as my sergeant from Franklin County Sheriff's Office was treated by a restaurant employee. Let us return to the respect of law. Let us not have that fear in the communities anymore. Let's work on that to where the police officer is the community partner, not the community agitator as some perceive or believe, rightly so. Let us put this in perspective that every single person that is wronged by the government has absolute rights, and that we should do everything we can to eliminate it from happening again, whether it be a person whose constitutional rights were violated by a government actor, or a person who is upholding the law and doing their job gets killed for no reason and is senselessly murdered. Thank you, Mr. Chairman.
Mr. Chairman.
Senator McClellan.
Mr. Chairman, I have two questions. One raised by the senator from Fairfax, and I think the question is more for Charles. As I recall, the last time I read Senate Bill 5030, the only penalties for a violation of any of the prohibitions in that bill were dismissal, demotion, or suspension, or decertification. If the acts prohibited in that bill result in injury or death to an individual, does that individual have any recourse civilly Okay.
I'll answer that.
Delegate Bourne, first of all.
No, John.
Delegate Bourne.
Mr. Chairman, I'm not sure that the question was to me. I think it was to Charles.
It was to
Charles
I'm not-
Quagliato, please.
I can answer that if anybody would give me a chance.
Thank you.
All right. The delegate from the city, the senator from the city of Fairfax.
I would answer the senator, where you have an expressed articulated legal duty, then qualified immunity doesn't apply because you already have a bright line standard that's in the law. So if you've brought for example, a wrongful death action, then you would just be able to show that by violating the standards that's in the police reform statute, they violated that standard of conduct and they should be liable. So qualified immunity would not come into play because, again, you would have a bright line standard under the code.
Okay, thank you. And my second question is, when will the Boyd Graves Conference be meeting again?
Anybody know when the Boyd Graves Conference is going to meet again?
No.
Mr. Chairman? Mr. Chairman?
Senator Morsi.
I'm told, but haven't confirmed, that it's not until October of 2021.
Matt, yeah.
Senator Deed.
Mr. Chair, the only reason I added that to the motion is because that's what we decided to do with Senator Morsi's bill. If there's, I don't think there's anything that prevents the chairman of this committee and the chairman of the courts committee in the House of Delegates from forming a joint subcommittee to work on this matter over the next few months, in lieu of going to the Boyd Graves Commission. In fact, that might be a more efficient, a better way to deal with this.
So is there a motion then that to amend the previous motion, they pass it by indefinitely, and the chair form a subcommittee to look into this further?
Mr. Chairman, if you want an amended motion to that effect, I make such motion.
We have a motion. It's been seconded by Senator Deeds. And the motion is the bill will be passed by indefinitely with the chair organizing a committee with the House, if possible, to look into this bill further. I know the bill will be back in any event. If that is the motion. Any further discussion?
Mr. Chairman, Servo.
Senator Servo.
Thank you. First of all, Mr. Chairman, that motion requires the acquiescence of a different body, and I'm not sure where. I would hope that they would communicate with us and collaborate with us.
Possible.
But I just want to say really quick, the same kind of situation happened last session with a couple other bills. I want to make clear that those of us voting in favor of this motion are not voting in favor of this motion because we don't want to do anything about qualified immunity. We need to do something about qualified immunity desperately. It is a big problem. It's been identified by a problem by numerous judges and opinions. There's an op-ed, and I think the Wall Street Journal today about it. I want to do something about it. I'm going to carry a bill next session about it. The issue with this bill is just the unintended consequence, and that's the concern. I want to make sure the public understands that, because every time we take votes like this, everybody acts like we vote to kill something, and that means we wanted to kill it. That's not what we're doing, first of all. Secondly, I just want to say, I keep hearing this stuff about the cost to individual families of getting sued for this stuff. The only people affected by the cost of this are insurance companies, and local governments have to pay insurance premiums. But I'm not aware of a single police officer who's probably ever had to personally pay a judgment. There's been a lot of confusion about this because of what Colorado did. And the Colorado statute specifically requires a police officer to pay the first $25,000 of any settlement or any verdict. We're not doing that here. We're not even talking about that. It's not on, so personal cost to police officers shouldn't be part of this discussion because it's really not an issue. And I'm a firm believer in using the litigation system to solve our problems. I mean, obviously I'm a lawyer and I got a little bit of a self-interest in that idea, but our litigation system is proven capable of solving a lot of society's problems once you create liability for things, whether it's, what happens with what's happened with making our vehicles safer, with what happens with a lot of other things. And I think that policing would actually be improved if there was increased liability for these things. So I fully support doing something about this. I think we will next session. We just need to stew on this and make sure we do it right. And that's why I'm supporting the motion.
The motion is to pass the bill by indefinitely, and it's not officially part of the motion, but the chair will form a committee, subcommittee, to look into this further for next year. Any further discussion? Before voting, I want to make a comment. I fully embrace the comments of Delegate Bourne and Senator McClellan. I think we all should. I think this is an issue that's important. I think it'd be helpful if we would take Senate Bill 5030, which we just passed recently, look at that and maybe tack on to it some other issues like liability. One of the problems I have with the current law is the sovereign immunity. You can't sue localities in Virginia. It's a very hard thing to do. So that would be perhaps a vehicle we could look at going forward. And also the whole question of qualified immunity, I've always thought is one that needs to be looked at more carefully. I think the Supreme Court's looking at it as well as others. Anybody else want to make any more comments? Are you ready to vote? Will the clerk please call the roll on the motion to pass by indefinitely with the understanding the chair will form a subcommittee to look into this further?
Senator Saslow. Senator Norman. Senator Lucas.
No.
Senator Obenshain. Senator McDougal. Senator Stewart. Senator Stanley.
Aye.
Senator Chafin. Senator Deed. Senator Peterson. Senator Servo. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey. Senator Edwards.
Aye. Senator Norman. First of all, let's hear the vote. What's the
12
outcome
ayes,
of the
3
vote?
12 ayes, 3 nays.
It's, Senator Norman.
Mr. Chairman, having voted on the prevailing side, I would ask that we reconsider the vote by which we pass by indefinitely.
All right, all in favor of the motion to reconsider, say aye.
Aye.
All opposed, no. The motion is reconsidered.
Mr. Chairman, I would.
Senator Norman.
Mr. Chairman, I'd make the motion that we pass it by indefinitely and also incorporating the reference to the subcommittee that you previously articulated.
That's the same motion, right? Okay, this motion is back before us, the same motion. Would the clerk please call the roll?
Senator Saslow. Senator Norman. Senator Lucas. Senator Obenshain. Senator McDougal. Senator Stewart. Senator Stanley.
Aye.
Senator Chafin. Senator Deeds. Senator Peterson. Senator Servo. Senator McClellan. Senator Boysko.
Aye.
Senator Morrissey. Senator Edwards.
Aye.
Ayes 12, noes 3.
Ayes 12, noes 3. The motion carries. Is that correct, Kobe? Okay. Is there any other business to come before the committee? Are you ready to rise? Without any further ado, the committee will meet again on Wednesday after the session next week, right after the session on Wednesday afternoon. The session starts at 10 o'clock, I think. And after that session, we'll meet to consider all the other bills that have been sent to us from the House. Without any further ado, the committee will rise.